All right, so back to our topics. Let's see. The next one I wanted to cover was Missouri. Missouri's passing a self-defense immunity statute. So let me pull that up for everyone. Not that tab, this tab. Senate Bill number 666. Unfortunate enumeration. Really, fellas, you could have done better than that. See if I can expand this a little bit, make it a little bit easier to read. So this is a kind of broad revision to Missouri's self-defense statutes. And in fact, in some ways, I think it has a harmful effect on Missouri self-defense law. I'll come to that in just a moment. Most of this proposed legislation doesn't change anything. So all this text you see here that's just like typed, there's no change here. That's stuff that remains the same. And it basically just steps through the 5 elements of self-defense for Missouri self-defense law. Missouri is a stand your ground state, so there's no duty to retreat and otherwise lawful self-defense. We have the elements of innocence, imminence, proportionality, avoidance is addressed, as I just said, and of course, reasonableness. Here we address deadly force as opposed to non-deadly force, which covers the element of proportionality. Then we get to the section where it begins to change. So this grayed in area here is stuff that's coming out or proposed to come out of the existing self-defense statute. And the bold stuff is new material that's proposed to be inserted into the self-defense statute. So let's look at the new material first. It creates this proposed language, creates a legal presumption of reasonableness under this section that the defendant believed the force necessary to defend himself that the defendant believed such force was necessary to defend himself or herself or a third person from what they believed to be the use or imminent use of unlawful force by another person. And that sounds good. I mean, it's always nice to get a presumption in favor of self-defense, but it's really mostly a feel-good provision because you pretty much already have a presumption that your use of force was lawful, because if you act in self-defense and now you're defending yourself in a criminal trial, that's because you've been charged with a crime. And if you're charged with a crime, we all are presumed innocent until proven guilty beyond a reasonable doubt. So this new language doesn't really add all that much. If you're claiming self-defense as a legal justification to some criminal use of force charge, you already have a legal presumption that you're innocent until that your use of force was justified, until the state has disproven that justification beyond a reasonable doubt. So this language doesn't really add much. The language they take out is a little troublesome, actually. So we have this first section. It says the defendant shall have the burden of injecting the issue of justification. So that's what I would refer to as the burden of production. Before you can argue self-defense in court in the first place, you have to show more than zero evidence in favor of the elements of self-defense. And by the way, folks, I've several times now mentioned the elements of self-defense. There are up to 5 elements of any claim of self-defense. This is true in all 50 states. If you don't understand these 5 elements, you can't possibly understand self-defense law. So that little thing I just held up was our 5 elements of self-defense infographic. We provide that for free to anybody who would like it. You can get that at lawofselfdefense.com/elements. We don't charge a penny for it. It provides, of course, it lists the 5 elements, provides a brief description. This is the very basic, most basic foundational knowledge you need to have to understand self-defense law in the United States, folks, no matter what state you're in. And we don't charge a penny for it. So it's just a PDF download at lawofselfdefense.com/elements. For those of you who are instructors and would like a poster size version of this, we do make those as well. They're not free because we have to print and ship them, but you can find the option to order a poster size version at that same URL. But you're not obliged to do that. You can just download the PDF for free right there. lawofselfdefense.com/elements. So the burden of injecting is really the burden of production. You have to first show there's more than zero evidence in support of each of the required elements of self-defense, or just strictly as a technical matter, what you did can't have been self-defense, legally speaking. If a required element is missing, it's not self-defense, technically, as a matter of law. So before you can even say the word self-defense in front of the jury, you have to show there's at least more than zero evidence in support of each of those elements. That's the burden of production. That's the burden of injecting. And then in every state, once you've done that, the burden of proof on the issue of self-defense shifts to the state. Now the state has the burden of disproving self-defense beyond a reasonable doubt. That's what all this language grayed out here is saying. And this is language being taken out of the statute. So maybe saying that the defendant has the burden of injecting, has the burden of production, maybe they feel that's a good thing to take out, because they're also, as we discussed, creating an initial presumption that the use of force was lawful. But then they go on to also take out the portion that says, and then the burden shifts to the state to disprove self-defense beyond a reasonable doubt. That's not a good thing to take out, folks. So I have no idea what they're thinking of there, because the burden doesn't have to be on the state. Traditionally, self-defense was a classic affirmative defense where not only did you have the burden of production as a defender, but you also had the burden of proof to prove self-defense by a preponderance of the evidence. Over the last several decades, that has changed. Now all 50 states put that burden of proof on the state to disprove self-defense beyond a reasonable doubt, but that doesn't have to be that way. So by taking this out, it opens up the door to a prosecutor arguing that, well, clearly the legislature did not want the burden to be on the state to disprove self-defense beyond a reasonable doubt because they took it out of the statute. That's a bad thing. Then this proposed law has more of this bold language, and this is where we create the self-defense immunity provision. So basically it says if you use force lawfully in self-defense, if your use of force was consistent with the elements of self-defense as defined elsewhere in Missouri law, you are immune from criminal prosecution and from civil action. And it also says that by being immune from civil action, it means you can't even be subject to arrest, being detained in custody, being charged, or being prosecuted at all. That sounds great, right? Here's the trouble. This is, as a practical matter, only triggered, this prohibition on even arrest or detention in custody is really only triggered, again, if your use of force was consistent with lawful self-defense. Someone has to make that decision. Until that decision is made, this stuff isn't triggered. And that decision may not be made at your arrest, at the scene, right? Or the people at the scene may decide, no, in our opinion, it doesn't look like self-defense. So you should presume that you will be arrested, regardless of this kind of language. Florida has the same language, and we have a lot more experience in Florida with this kind of stuff. And in Florida, I know very prominent, respected by me, criminal defense attorneys are adamant that their client ought not even be arrested until basically self-defense has been taken off the table, disproven beyond a reasonable doubt. As a practical matter, that tends not to be what happens. As a practical matter, the officers on the scene decide to make an arrest. So despite this apparently positive language, you should presume that you'll be arrested. Another thing I should point out is that so once you've done this, once you've made a claim of self-defense, you have this prima facie case. There's more than zero evidence in support of the elements of self-defense. You can then request a pre-trial immunity hearing. We talked about this in a lengthy 2.5-hour show just earlier this week. You can have a pre-trial immunity hearing. And in that hearing, the burden is on the state to disprove self-defense by clear and convincing evidence. That's more than a majority of evidence, but less than beyond a reasonable doubt. If the state cannot disprove self-defense by clear and convincing evidence, the court is supposed to grant you immunity. Now, I did want to touch upon another subject because this was ambiguous when we spent 2.5 hours earlier this week talking about a self-defense immunity case out of Florida. And that is the way the Florida, and really this statute as well, this immunity statute is written, it would appear, and I know in Florida for many years, this was how the law was applied. that if you were charged with a crime for a use of force event, you claim self-defense, you demanded a pre-trial self-defense immunity hearing, um, based on those criminal charges. And that's like a mini trial. So the prosecutor is there arguing against self-defense. Your defense counsel is there arguing for self-defense. The judge acts as the judge and the jury in this pretrial immunity hearing. There's no actual jury in a pretrial immunity hearing. And it's kind of like a mini trial. It's an adversarial process. And if the state lost there, you were granted immunity from criminal prosecution and immunity from civil suit, both at the same time. And you might think, well, that makes sense, right? Either you should be granted immunity or not. But it was always struck me as odd because there's different parties involved in the criminal action and in a civil action. So in the criminal action, you have the state represented by the prosecutor and, of course, your defense. But the civil party is not represented in that adversarial process. So if you're arguing for immunity from criminal prosecution, anybody who might want to sue you is not a party to that pretrial immunity hearing. They're not making their own arguments. Plus, the legal threshold is arguably different. So the Florida Supreme Court has since handed down a decision, created case law, that just because you may have been granted immunity from criminal prosecution in a self-defense immunity hearing in a criminal context does not mean you automatically have immunity from civil suit. You would actually have to have a separate self-defense immunity hearing in the civil context with the plaintiff represented as a party, do it all over again, and get granted immunity separately for civil law purposes. And I imagine that's ultimately what would happen here. Now, this is being called controversial. It's not at all controversial, this proposed Missouri immunity law. I don't like the stuff they were taking out earlier about the burden shifting to the state, as I mentioned. But the immunity provision itself is pretty straightforward, normal, traditional self-defense immunity, as many, many states have adopted. It's always called controversial because it takes power away from the prosecution and it takes power away from civil litigation attorneys, because this relatively inexpensive procedure, this pre-trial self-defense immunity hearing, can cut them off at the knees. Now the prosecutor, if you're granted immunity, now the prosecutor doesn't have the power to use the process of the trial itself as a punishment, to compel you to incur hundreds of thousands of dollars in criminal legal defenses expenses, and the risk of getting convicted and spending 20 years or life in prison. That stops if you're granted immunity at this relatively time-efficient, cost-efficient pretrial immunity hearing. Prosecutors don't like that. They have less power now. So prosecutors are invariably opposed to self-defense immunity provisions like this one. So they'll call it controversial. Of course, civil litigators don't like it either because it cuts off their ability to either sue you in court or to compel you to settle out of court, because again, this relatively time efficient and cost efficient pre-trial hearing can cut them off at the knees. Then you're granted immunity from their civil suit and they can't do anything to you. And civil litigators are powerful political entities. They make lots of campaign contributions to politicians to protect their interests. And so they will fight very aggressively against these kinds of self-defense immunity provisions, which really tells you all you need to know about how important they are for actual lawful defenders. Okay, let's see. The next topic I wanted to cover was this TikTok door kick challenge.